therefore I'm going to stop you now, and therefore you have to pay a fine. I think with such a situation I have a problem. And the second situation where I have a problem is if it's not the legislator deciding that the speed limit is reduced from 90 to 70, but it's somebody else. And I think this is also part of the debate, which goes to the roots of the democratic system, I think, that now we have the G20, we have the OECD, we have all kinds of international institutions and organizations, and sometimes not even international organizations, which are leading the debate and which are making the decisions. And the democratic legislator, the democratically elected legislator, is just implemented what had been provided by soft law. And I think this is the core of the issue, I think, those two problems I have. So coming, Mr. Chairman, to the issue of the GARs, how is the issue connected to the GAR problem? I think I realize that many countries have either now introduced GARs or are considering introducing GARs, and I'm not at all convinced if this is the right direction. Why? Because I think Jeffrey Owens a few minutes ago has made reference that we should not look only at the letters of the law, but also at the spirit of the law. And I think this is completely right. I completely agree with that. But I think this is nothing new under the sun. I think lawyers, educated lawyers, have done that for decades, for centuries even. And I think also in the tax environment, in the tax area, I think somebody, lawyer who was involved and who is involved in tax planning, well, if it's a good lawyer, then this lawyer has never looked only at the letters of the law, but also at the spirit of the law, and checked whether the structure he's proposing is in line with the spirit of the law. And I think that's the business, has always been the business of courts. And for an educated lawyer, and at least this is also what we are telling our students, the words, the letters of the law is just the beginning of the interpretation. It's never the end of the interpretation. You start with the letters of the law, but you have to take into account the context, you have to take into account the spirit, the intention of the legislator, and so on. Lots of the issues and lots of the arguments which had been mentioned by Jeffrey as well. I would just be careful with some others he has mentioned at the end of his short introduction, because I'm not so sure when we want to find out what the spirit of the law is, that this has something to do with the right ethical tax rate or whatever. So I think here we have to draw a sharp borderline. I think we should look at the subjective intention of the legislator at the time when the law was introduced. We should look at the context of the law and the whole purpose of the law. I think this is exactly what we have to do, but we have exactly to draw the borderline which values can we derive from the law and which are other values, very personal values, values which are prevailing in society. And this might make a big difference, and I think this is the big challenge also for tax administrators, but in particular also for courts, to draw the borderline between the values which can be derived from the law and which are the prevailing values in society, and this, or the personal values of the persons who are applying the law. And this is a big difference. And why are GARs in that respect dangerous? Because I think they prevent us from being aware of that borderline. Because GARs, usually, of course, GARs might be drafted in different ways, but usually there is also a subjective element looking at the intention of the taxpayer, and at the end of the day, I think this is the entrance door for taking into account the values of the persons who are applying the law, either the government, the tax administrators, or the judges at the end of the day. And I think this is dangerous because this prevents us from distinguishing between the different values. And the second reason why I also think GARs are quite dangerous for a legal culture is that I think at the end of the day, they are deteriorating the legal culture and the law as such. Why? Because, as I've said before, I think educated lawyers always have looked at the spirit of the law. And in order to cover situations which should be covered under the law, you have to look at the spirit of the law and the intention and the object and purpose. But once you have a GAR, then you make it quite easy for tax administrators and sometimes even for judges in only to look at the spirit of the law in those exceptional situations where they think this situation should be covered. But in the regular situations, in the standard situations, they just look at the letters of the law. So therefore, I think we are back to the Stone Age to a certain extent, because in most legal cultures, we have a development that we have been looking at the spirit of the law. And if we have GARs, there is the danger that we forget about the spirit of the law and only look at the spirit of the law in very exceptional circumstances, very exceptional situations. So therefore, I think it's bad for a legal culture to have GARs. If we don't have GARs, then tax administrators and judges are forced to look at the spirit of the law and find out what the spirit of the law really is in order to see whether a certain situation is covered under the law or not. So therefore, for me, GARs, that's not so much or not at all an issue of legal certainty, because I think it's an illusion that if we just look at the law as it is published, that we know immediately what the content of the law is. I think this is never the case, and this has never been the case. So therefore, in respect of legal certainty, I think GARs don't make the difference. The law is to a certain extent uncertain, and we have to do research, and we have to look at judgments, we have to look at material, whatever, in order to find out, in particular for border situations, to find out where the borderline of the law is, where the scope of the law ends, and where it's beyond the scope, we have to look deeper. So it's not a question of certainty, but it's a question of in which situation do we take into account the spirit of the law. And again, I think this is the big risk. Once we have GARs, once we introduce GARs, then we tend to look at the spirit of the law only in very exceptional situations, and in all other situations we are back to the Stone Age and apply the law in a very primitive way.
Jeffrey, before you give a counter to Michael, I just wanted to have a view from Mr. Akhilesh Ranjan, because he, in his capacity as competent authority, is not in the middle of debating the GAR legislation in our country, but also is India's spokesperson in the OECD, and what India expresses in the OECD BEPS project will be important. Mr. Ranjan, your comments?
Thank you, Mukesh. Some very compelling arguments made by Michael out here. Certainly very fresh way of thinking and looking at GAR. And I think that is what is required. The debate must move away from these old arguments of certainty and predictability to what is the objective of GAR. Can that objective be met otherwise? Why does GAR really fit into a modern legal system? I think I just like to make a couple of points. One is that we have to look at GAR in the perspective, in the proper perspective. Let us not. We have been talking about the last 1 hour of various debates between substance and form, of morality and immorality of the taxpayer or of the legislature. I think these questions are all now they arise from old and outdated concepts. They must not be thought of as relevant any longer. There are judgments which say that people must not pay more tax than what is required by law. I think that goes contrary to the present philosophy, where tax systems have to be based on voluntary compliance. So there is a clear contradiction. I think we are living in a time, in a place which is far removed from the context in which those judgments and those debates had arisen. So the point is that we have to look at the current perspective. Where are we now? We are at a place, at a very important crossroads in the history of taxation, where the world is realizing that the current rules do not work. The current rules are not capable of ensuring that every jurisdiction gets its fair share of taxes. They are not capable of ensuring that every business pays what it should be paying in the right place at the right time. There are movements, as Michael had mentioned, and there are movements by the G20. There is a base erosion and profit shifting anti-base erosion and profit shifting project. There are various bodies going into these issues as to how to ensure that taxes are paid where value is created. And I think it is in this context we must now get away, as it was said in the McDowell judgment, we must get away from the ghost of Westminster. That was 1936, for heaven's sake. It's 80 years almost. I think we have moved on. The world has moved on. One has to now consider and accept the multilateral initiatives coming up at various levels in various fields, the cooperation, the need for cooperation, for exchange, which is recognized not just in taxation but in all economic activities. In this context of close interlinked nations and transactions, I think it is now pointless to say that, okay, to go on to the debate of form and substance. Coming to the thing of GAR, well, my personal view is that it's being looked at in a very incorrect perspective. Some people look at it as a magic wand which can get you the taxes that you can't get it otherwise, which is wrong. Some people look at it as a sledgehammer. Okay, that's what the tax department will hit you with if they can't get you with any other law. I think both perspectives are wrong. GAR is nothing, it's just a law which is trying to prevent the abuse of existing laws. So it is trying to set right a system which is now trying to corrupt the legal system. And if the objective of GAR is understood in that context, then all that remains is the care required to be taken in drafting that legislation, in implementing that legislation, and in ensuring administratively that GAR is used in the right place at the right time and the right circumstances. So I think GAR is very much relevant in the current scenario. I think we need to move away from the debate of 20 years ago. We need to look at what's going to happen in the next 10 years or 20 years. And if you look at that, we will clearly see that the current laws and the rules are not adequate. They have to be modified, they have to be changed, and in order to bring out the real intent of this change and this modification, a comprehensive set of GAR rules has to be brought in and accepted as a requirement.